Hello. Oh, yeah. You're ready? Okay. ఉంది కదా అది డౌన్లోడ్ చేసుకున్నావు కదా? Okay. Okay. Right.
Sir, good morning, sir.
Good evening, Andy.
Sir, good evening, sir. Sundaraga.
Sir, good evening, sir.
Sir, good evening, sir. Sundaraga.
Sir, good evening, sir. Good evening, sir. Sir, we'll wait for 5 minutes, sir.
Yes, sir. Yes, sir.
Madam joined, sir.
Yes, sir. Madam joined. Madam.
Okay. Good evening, madam.
Hamza, madam. Good evening, madam.
Good evening, sir. Good evening to all.
Yes, sir. Yes, sir. Our chairman, sir, Dr. Badhu Sundar are also on the line, ma'am. Sir is also.
Good evening, madam.
Sir, good evening, sir. Good evening. Good evening. Good evening, everybody.
Ma'am, the session is actually 7 o'clock, but we'll wait for another 5 more minutes, ma'am, because members
Okay.
are slowly, they're logging in.
Okay, sir. Okay.
Yes, ma'am. Yes. Rohit Chandra garu, good evening. Yes, sir. Good evening, sir. Actually, ma'am, all of us are here, working professionals, so everyone are busy with their work. Slowly, like that's why, we have chosen this time.
No problem, sir.
7 o'clock.
Good evening, Murthy garu.
I understand, sir.
Good evening. Good evening.
Good
And
evening.
moreover, second Saturday and fourth Saturday is banks holiday for us.
Yes, sir.
So most of the valuers, they work with banks, and most of them are busy with them.
Yes, sir.
That's why we prefer either second Saturday or fourth Saturday as our webinar.
Okay, sir.
Actually, all the valuers here are, they are of two categories, ma'am. One is land and building,
Oh, sir.
and other one is plant and machinery. And 95% of the valuers are land and building.
Land.
Of course, being a panel legal advisor, all this. It's not-
Yes, sir.
because we'll be going through a lot of documents.
Yes, yes, yes. Mostly, all of the values will be civil engineers only, sir. For plant
Yes, ma'am.
application, mechanical engineers will be needed.
Yes, ma'am.
They will be separately appointed as
Yes, ma'am.
valuers.
Yes, ma'am. 90% of the valuers are civil engineers, ma'am.
As civil engineers. Yes.
Yes.
Yeah,
Hardly
get the meeting
5%.
was much.
Like earlier, like 10 years back, banks, they used to even engage civil engineers for even plant and machinery also. But later on, it is categorized and now exclusively, if it is industries and all, it should be done only by plant and machinery evaluator.
Yeah.
And immovable is by civil engineers.
Civil engineers.
Yes, ma'am. Yes. Devaprasad sir, good evening, sir.
Murthy sir.
Yes, sir.
Murthy sir.
Yes, sir. Tell me, sir.
How many are there, sir, right now?
Sir, sorry. We'll start, sir.
How many are there, sir?
Around
What is the
19, sir.
number?
19, sir. Around
19, sir.
19.
19, sir. Yes, sir. We'll start, sir.
Okay, sir. Okay. Slowly they'll add up. We are expecting around 40 to 50, sir. We'll start, sir. We'll start.
Yes, sir.
Yeah. Ma'am, we'll start, ma'am.
Yes, sir.
Yes, sir.
Yes. Good evening, everyone. A warm welcome to all the fellow value members. Today we have Madam Sunkara Padmaja, our speaker of the day. Like as I was telling, ma'am, it's been a long time, since we have invited a legal advisor. Ma'am being, panel legal advisor for nationalized banks and NBFCs, I think, she's the right choice for us, like we can interact with her after our session. It will be very useful for us. Whatever, if you have any legal queries and all, we can get it clarified from madam. Now I request our executive member, Sri Vamsi Santosh, to give a brief introduction about our speaker. Over to you, Vamsi.
Yes. Good evening, everyone. Am I audible?
Yes, yeah. Good evening.
Yeah, good evening. It is my privilege and honor to introduce our esteemed speaker, Srimati Sunkara Padmaja Garu, a distinguished advocate with a successful legal career spanning over 35 years. Srimati Padmaja Garu holds master degree in law and arts, along with post-graduation diploma in industrial relations and personal management and public relations, reflecting her strong academic foundations and multidisciplinary expertise. She has been practicing before the District Court of Visakhapatnam for more than 3 decades, specializing in civil, criminal, and banking laws. Throughout her career, she has served as panel advocate for several nationalized banks and NBFCs, HPCL, and Indian Oil Corporation. She has also rendered distinguished services as a former standing counsel for the GVMC. A proud daughter of Visakhapatnam, Srimati Padmaja was born, brought up, and continued to serve the city through her legal profession with dedication, integrity, and commitment to justice. She is supported by her husband, Sri S. Bhaskar Rao Garu, a mechanical engineer who served as general manager in power sector and is presently engaged in engineering contracts works in Visakhapatnam. She is blessed with 2 accomplished children. Her son, Sri Sai Arun Kiran, graduated in engineering from NIT Srinagar, completed his master's in project management from Australia, and is currently serving as Deputy Registrar in Narsi Monji Institute of Management Studies, Mumbai. Her daughter holds an MTech from Sastra University and Bachelor of Law from Andhra University. She is recently married and now settled in Canada. With her vast professional experience, profound legal knowledge, and unwavering commitment to the legal fraternity, Srimati Sunkara Padmaja has earned immense respect among her peers and clients alike. Ladies and gentlemen, please join me in extending a warm welcome to our distinguished speaker, Srimati Sunkara Padmaja. We look forward to benefiting her from her wealth of experience and valuable insights. Thank you. Over to you, madam. Madam, unmute చేయాలి.
Yes, ma'am, you can start, ma'am.
Yes, sir.
Yeah, please.
Yes, sir. Respected Chairman, Secretary, and Sri Devi Prasad Garu, and other dignitaries who have participated in the webinar. It is a great and immense privilege for me to talk in front of you all to share a few words related to the title trust, legal safeguards in property valuation. Sir, I present you what is a title to trust. It is a bridge. It bridges law, banking, real estate, and risk management. What is title? Legal ownership of property. What is trust? Confidence that the property is legally clean, secure, and safe for investment or lending. What is valuation? Determining the true economic worth of a property. A property's value is not determined by only the market price or physical appearances. Its legal safety directly affects its value. As lawyers, we convert uncertain title into trusted collateral. When a property is bought, sold, mortgaged, inherited, or offered to bank for a loan, the question one is, does the person legally owns this property? We, as an advocate, we will question us whether the person legally owns this property. That is, it goes for title verification. And question two, what we think about is what is the actual safe value of this property? Property valuation. Property valuation, it comes under valuer. If a title is defect, even 5 crore property may become legally worthless. That is why we say good valuation begins with good title. Legal strategy for managing complex property issues. First of all, we have to collect the documents, and next we have to examine the root title of the documents, verify the EC and encumbrances, charges, claims, etc., and also check the revenue records if it is property relating to agriculture, and then go for such litigation. Whether we have to find out whether any encumbrances or any defective title are for any defective title means I mean that is the survey numbers, whether property given to us particular survey number, and if we find out any defective survey number in process of such litigation, we have to find such defects. These are all legal defects. We have to, as a lawyer, we identify the legal defects, and ongoing all these process. After that, we issue a legal opinion. Legal opinion means it means clear title, marketable conditions, and marketable conditions. If it is a defective title, we simply reject that to give a legal opinion. What are the legal safeguards in the property valuation? Property valuation without legal due diligence is incomplete. Suppose a commercial building worth rupees 10 crores is offered to a bank. Valuer says if it is a property situated in good location, and strong, and it is construction is very strong and it has high market demand value. But lawyers finds that property is under litigation, illegal conversion from agricultural land, existing, and if there is an existing mortgage with another bank, these lawyer finds out all these problems, all these issues, and says that the property is not having clear marketable title. Now market value becomes irrelevant. The legal safeguards which we have to take into consideration and to protect the buyers, sellers, banks, financial institutions, investors, and government revenue. First, property title. Property title is not a single document. It is a legal chain proving ownership. Having any doubts, sir?
Yeah, I think
Madam, proceed, madam.
Babu is having a doubt. Ma'am, question session will take up at last. I think that
Yeah,
way.
okay, sir. Okay.
Siddharth Babu, we can, ask the queries at the end of the session. Thank you.
Sir,
Yes, ma'am, please proceed.
title documents include sale deeds, gift deeds, revenue records, sir. Sale deed also includes sale deed, gift deed, everything includes partition deed, release deed, settlement deeds. It may also include will plus probate, court decree, patta mutation entries. A strong title requires clear chain of ownership, usually 30 to 40 years of traceable ownership. Sir, since my practice as a bank panel advocate, we are suggested by the bank to look out to trace the value from 30 years, minimum 30 years of traceable title. We have to find out, sir. Without 30 years legal ownership, a chain of title, we are refusing to give any legal opinion. Next, the property must be a lawful transfer, sir. Lawful transfer. Each transfer must comply with the law. It's a legal transfer. Then property should not have any encumbrances. It means encumbrances, no mortgage should be there, liens and charges or claims, attachments over the property which the borrower is intended to mortgage the property to the bank. There should not be any pending litigation with subject to that property to be mortgaged with the bank. So clear property without litigations to be presented before the bank, and then we can go for a legal opinion, sir. And and with regard to valuation, sir, legal safeguards in property valuation, sir, I would like to bring to your kind attention that first valuer has to seek for a legal opinion which is given by the panel advocate, sir. Panel advocate. And valuer has to check the legal opinion and the encumbrances of the property, revenue records, revenue record verification, and also land use verification, litigation search, statutory approval verification. That means whether the property, whether it is properly laid out, proceeding, whether it is by competent and authoritative proceedings are given for proper layout of the property, and also building with respect to building constructions, whether proper competent and other has issued any approval building plans. Then we have these are the guidelines and which are binding to the valuer as well as the lawyer before to find out the legal safeguards on the property to go for legal opinion as well valuation of the property. Coming to the advocates part, it is for us when bank sends us the documents for a title due diligence, we require lawyer verifies first main root title of the document, that parent documents, then chain documents, and also the ownership continuity, whether it is coming from, as I earlier told you that 30 to 40 years of chain link to be established, whether it is established or not, we will verify, we'll check it up, whether property flow of proper chain link up is there or not. And all the question of legal heirs, succession rights also arise in the due course of our preparation of legal opinion. There are also some red flags for a legal opinion to give a where in case we reject to give a legal opinion. That is some missing linked documents. If there are any unregistered transactions or forged documents and misuse of power of attorneys, these are all some of the red flags wherein we reject to give a legal opinion as an advocate. And also we go for first other aspect is encumbrance certificate. Encumbrance certificate shows registered transactions like sale. If it is registered mortgage reflects in the encumbrance certificate, registered lease deed, registered release deed, or registered gift deed. Only registered documents will be reflected in the encumbrance certificate. But we have to note that every EC does not show, always show that property is clear, whether it's mortgage or not. Some of the we can come across several opinions on takeover loans like that. We find out that some private banks, they will not get the property registered mortgage. They'll just simple equity mortgage, they will sanction the loan and issue that loan process will be done. So in that case, we cannot find out in encumbrance certificate. In that case, we ask for a letter from such private institutions where property is mortgaged with them. Then only we can confirm that property is mortgaged. Otherwise, if no letter, nothing is there, we cannot find out the property is mortgaged. And we also ask for original title deed verification before issuing the legal opinion. And if the person borrower doesn't bring the original document, then we'll get a dot. Then we'll go compulsorily insist for original document. Then if anything is fishy, then all these will be coming. That like that it is properties in, whether it is in finance decision or private mortgage, like that. So before going for issuing a legal opinion, as an advocate, we will go through all these issues. We will verify all this. In Andhra Pradesh, we have in Andhra Pradesh and Telangana also we have registered verification through online through IGRS for that. So just manual for our just ready-made information, we can check it in from the IGRS whether the property is registered or not. But that we cannot confirm from the EC, but we have to thoroughly go inside to know the real facts of the property. Next, coming for revenue record verification, it comes under when property is agricultural land, then this revenue record verification will be coming into picture. In revenue records, generally we have Patadar passbooks, Adangals, 1B register, and mutation of entries in the Patadar passbook, survey records, SFA, settlement deferment, SFA, FME sketch, we verify these documents before issuing a legal opinion. And even today we have we can go through online checking also to confirm whether the documents furnished to us are true or fake or forged. Mismatch between title deed and revenue records is dangerous. So sometimes the boundaries will differ. Sometimes the survey numbers, subdivisions will differ from title deed to revenue records. In such a case, we have to think over before giving a legal opinion. Next coming is land use verification. We have to check whether land is agricultural before this aspect comes under value, or mostly when it receives look after whether the agriculture, residential, commercial, or industrial, assigned land, seedling surplus land, endowment land, waqf land, and government land. Wrong classification of these lands leads to legal risk. Then how to find out those litigation search with respect to the properties offered for mortgage. We have to check in civil courts in the local circle where the property is situated, high courts, DRT, Debt Recovery Tribunal, NCLT, surface proceedings, where the surface proceedings are pending in the DRT court, and also revenue appeals. This legal aspect, which is to be searched in civil courts, different courts, it takes a lot of time and to find out the genuinity of the property. So with utmost care and caution, we have to go through all this. If the proceedings are if we have any doubt with regard to legal proceedings, with utmost care we have to go through and search and find out the solution. And if a matter of the property is in pending litigation, the property values depreciates. Statutory approval verification for buildings. Valuer or even advocate verifies whether the layout is approved, whether the permission for the building construction is given by proper competent authorities, and in case of apartments and flats, occupancy certificate and completion certificate, and also for RERA registration. Real estate RERA registration means Real Estate Regulation Development Act 2006. RERA applies to many real estate projects through Real Estate Regulatory Authority. The governing body that enforces this act, called Real Estate RERA registration, is mandatory in legal process, which is important for open plot buyers. When we go for purchase of open plots, we have to know all these rules, whether the property, or the real estate holder, real estate company is having the RERA registration, and that's where the particular property is properly approved, plots are properly approved or layout, and after confirming all these only, the proposed purchase of plot buyers have to step forward to buy the plots. See, there are some methods of property valuation also. I would like to bring to your notice that one is market approach and cost approach, income approach. Market approach means compare with the nearby similar properties. That factors that come under this are that locality, that road width, demand, and amenities. If these are provided or available within the particular property, then the market value differs. According to these, the amenities only, the value of property varies. Cost approach. Cost approach is value based on land value plus construction cost minus depreciation of the building. If it is new building, depreciation doesn't come. If it is old building, land value on construction cost minus depreciation. And it is especially used for factories, schools, and hospitals. And third one is income approach. For income generating properties like malls, offices, rental complexes, value is the net annual income. That is our capitalization rate. Capitalization rate. Factors affecting property valuation. There are three types of effects that property for valuation, that is fiscal, market, legal. Fiscal in a fiscal aspect, with respect to fiscal aspect, area, construction, quality construction, the age of the building, and access to the transport, public roads. Market, with respect to market, we had to take a demand of the particular area, infrastructure like metros and highways. In case of legal, title clarity, you require title clarity, zoning, litigation, approvals, and mortgages. And one of the important factors in we have before purchasing or before valuation or before giving legal opinion, we had to see that the main aspect is easement rights on the property. It is not out of place to mention that it is also onerous responsibility of the valuer to guide the banker by identifying defects, drawbacks in the properties. Most of the time, properties will be burdened with easement rights of way or land, being landlocked, making it necessary to rely on the neighbor property to access the land. Therefore, making it impossible for the authorized officer to sell the land at the time of auction. One major bank problem where bank is fighting disputes with a neighbor every time an attempt to sell is being made, and it becomes the duty of the DRT tribunal, tribunal, to obtain a map to direct banker to all the undistributable portion after identifying the saleable property. So before inviting such a huge problem to the banker, it is our duty. Duty means it is our responsibility of the valuer, banker, and also valuer. All these three have to find out the access of the property, so that according to that, if in case of the borrower commits default, and the account becomes NPA, the banker can sell this that property without any hindrances. This saga could have been eliminated in the value if the valuer identified the pre-existing easement of way on land and demarcated the same. And the risk factors affecting property valuation. Illustrative risk impact score out of 100. Title defect is more. Litigation. Next comes to litigation. Next comes to mortgage. Next comes to approval issues and market fluctuations. Last is the market fluctuations. Next is common property dispute causes illustrative distribution of litigation sources. That is, this is mainly bond issues, frauds, GPA sales, inheritance, mortgage conflicts. These 5 points are very much important for every purchase or ordinary person, common man, a banker, valuer, a lawyer. We have to ascertain all these things before issuing a legal opinion. And illustrative property value trend. Sample trend have shown trend showing increase in guideline value over time. At 2006, it has reached a high value over 2026. And some of the, I would like to mention some of the Indian laws which are necessary just for purchase of property or some ownership of the title of the property. What are the acts that are that will be guide us or rule us for a sound registration for a document to be registered, and what will be the effects of that. And one is the Indian Registration Act 1908, Transfer Property Act 1882, Indian Stamp Act 1899, Specific Relief Act 1963, Surface Act 2002, RERA Act 2016, Indian Succession Act 1925, Limitation Act 1960. So just a simple, just only few, 2 or 3 sections I have mentioned. with respect to Registration Act 1908, Section 17 of this Act tells us the compulsory registration. Every document to be registered compulsory, registered document to be registered compulsorily. And Section 45 reads that effect of non-registration. If the property is not registered, that it will have not have any legal entity. So these two sections primarily tells us about the registration of the document. If a sale it is not registered, weak legal enforceability. It cannot be enforceable. It will not be taken by banks or any person. Even for purchase also, we cannot go for unregistered documents. Next act is Transfer Property Act 1882. Three sections I would like to mention. Section 54, sale, deals with sale. And Section 58 deals with mortgage. And Section 105 deals with lease of property by transfer of lease. These three sections defines property transfers. Next, third act is Indian Stamp Act 1899. Deals with stamp duty, undervaluation, revenue protection. Specific Relief Act 1963. Used in specific performance suits and in property disputes. Specific performance suits and property disputes. This act comes into attention of the persons who propose to purchase the property or already purchased properties. For example, the sale agreement entered into by one of the purchaser. Even he pays everything in advance, everything, but the proposed vendor fails to register the document, register the sale in his favor. Then he can approach the civil court to get the property registered, and he files a specific performance suit to get the sale deed registered in his favor. Like this, many of the issues are there for specific performance suits. This is one of the example to be just for understanding purpose. I have submitted before. Next coming is Surface Act, it's 2002. This is the latest act which is prevailing, where the banks are following this 2002 Act. The central government has envisaged this as passed this act, and from the date of surface, this act has come into force. Banks are enforcing this security enforces security interest without lengthy civil suits. That means if a borrower approaches the bank for a loan, and if he avails the loan, and if he commits in default in paying the installments, then the bank need not file a civil suit or a commercial suit for recovery of the amount, that amount due by the borrower. Then he can directly follow the rules and guidelines laid down in the Surface Act. Then he can, it gives notice as per according to the Surface Act. Then he can, after following all the rules, he can bank and directly sell the property to the go for auction, and the bidders who are and anybody can bid that property. That is the legally enforceable act done by the bank. This is very much useful to the bank, and the bank can nowadays recovering the amount which are due from the borrowers through this securitization proceedings. And it is important for mortgage recovery. Why a loan is becoming non-performed asset NPA? Wherever a firm approaches the bank for loan, bank collects KYC, assess the credibility of the borrower for repayment of loan and interest. After satisfying the details, they seek the legal opinion from an advocate, and and value offered as security, as surety from a valuer. Out of the value indicated by the valuer, bank will sanction loan of about 70% of the value subject to this eligibility, subject to his eligibility. If the borrower has failed, bank has to find out the reasons for failure, whether they are interlocked, whether they're intentional defaulters or due to change circumstances beyond his control. If it is intentional, it is to presume that he has misguided, produced forged documents. Bank has to take suitable action against the borrower as per law. If the failure is due to a change circumstances which are beyond to his control, after due inquiries, bank has to give some extension of time for repayment with fine or extra rate of interest as deemed fit. This is not only facilities the borrower, but also the bank is not losing their money. As black money plays a key role in the real estate, will not be able to realize their monies when they put the asset for auction as white money to be paid, which is accountable. This is a social problem. If we take a closer look of the process of valuation, there is a key difference between the values at the time of advances and the values at the time of recovery of NPA account. As most of you are aware, the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002 states that valuation of the authorized officer should be done by a valuer who is approved by the board of the bank. In other words, a very senior valuer need to value a property for surface proceedings, which will have to do accepted by the committee of a secured creditor. In case of default committed by the borrower in non-payment of the monthly installment amounts continues with 3 months, the account is automatically declared as NPA as per the guidelines of the bank. Before going for auction of the mortgage property by the bank issues letters to the borrowers, guarantors, etc., that the account is declared as NPA, and as such, the borrowers have to repay the outstanding dues repayable to the bank. And if the borrowers fail to do so, then the bank is empowered to sell the mortgage properties for recovery of the loan together with interest, etc., and the Surface Act 2002, duly following the rules laid down in this act. And as you all aware, that RARE Act protects the home buyers. RARE Act protects the home buyers, ensures transparency, timely delivery, and project disclosures. Next act comes is Indian Succession Act 1925. This is important in inheritance of the property from ancestors. Limitation Act 1963, relevant for adverse possession and old claims. In Andhra Pradesh, we have got specific legal developments recently, in the recent times also, that they have has go down digital registration and other integration, market value revision. This is every time, time and times, for every 6 months, market value is revised. Section 22 of proprietary properties and move integration. Digital registration, Aadhaar and integration. It speaks that Andhra Pradesh has increasingly digitized registration via IGRS, biometric authentication, online appointment booking, digital document scrutiny. This reduces impersonation and fraud. By all these methods, the fraud, impersonation is reduced. Market value revision. AB periodically revises guideline values for registration. Recent revisions affected urban areas from February 2025 and further proposals in 2026. And to speak about Section 22A of speaks prohibited about prohibited properties. This is very important in AP. Under Section 22A, certain properties cannot be registered. Example, like properties like which comes into the government lands and also ascent lands, endowment lands, work lands, and disputed lands. Always, we have to always verify that the property falls on Section 22A, at least before valuation. Even the buyers, before purchasing also they have to approach some advocate or they have to approach some list office to verify, to check where the property falls under Section 22A. And after confirming that the property doesn't fall under Section 22 only, they can proceed further to and make a plan for purchase of that particular property. Me Bhumi registration. Me Bhumi portal helps to verify the survey numbers, ownership of the property, arangles, and land classification. Arangles also reflect the name of the parties and also survey numbers, extent, etc. Land classification, whether it's agriculture or non-agriculture, also we can confirm from it. And I would like to bring you to the recent developments in India 2025-2026. Digitalization of land records and draft registration reforms, AI in valuation. Through Digital India Land Records Modernization Program. That goal is conclusive titling, GIS mapping, and fraud reduction. This digitalization of land records helps us to confirm these on conclusive titling, GIS mapping, and fraud reduction. Draft registration reforms. India is moving ahead towards e-registration, video verification, Aadhaar and linked registration, digital certificates. And AI, latest trend in valuation. Banks are increasingly using automated valuation models, geo-tagging, satellite-based verification. Strategic benefits of legal safeguards for buyers, for sellers, and for banks, for lawyers, for investors. These five I have to all together have to search before for these five. These are the safeguards. One, for buyers, to avoid fraud. For sellers, get fair valuation. For banks, reduce NPA risk. For lawyers, provide accurate legal opinion. For investors, make safer investments. These are the strategic benefits of legal safeguards for all five. And some of the key benefits and potential challenges even today. Title verification in India often remains partially manual. Okay, with respect to if we have very old documents, then we had to go for any advocate has to approach some concerned register office for verification of the title is whether the property is really registered there or not, and also verify with the original deed and also certified copy of the document, relevant document. What are the benefits? The benefits are it prevents fraud, protects ownership, improves loan security, reduces litigation, and enhances trust, strengthens financial system. Some of the potential challenges also there existing. Sometimes old records will be missing in the register offices, some in revenue records, some etc. etc. Manual verification needed. Sometimes it will be difficult for verification manually in revenue records or in concerned register offices. Revenue data mismatch, fake documents, and court records fragmented, and delayed mutation. What are the core learning objectives? The following are the core learning objectives with respect to the title and valuation route. First, to educate, explain. We have to educate, and that means explain title and valuation relationship. These two go together, giving to making the property truly valuable, truly correct and valuable. create awareness. Property value depends upon the legal validity. Reduces risk, encourage due diligence of the property. Improves compliance. Promote lawful transaction. That is between buyers, banks, and legal professionals. Some of the key legal insights are registration. If we go for registration, it guarantees our ownership. High market value is safe and is not safe and collateral. Mere registration doesn't guarantee ownership. High market value is not safe collateral. Mere possession is not a legal title. Never skip documents for verification. Legal due diligence is mandatory. So, real world challenges faced by the lawyers and bank panel advocates. I would like to bring you notice that some missing parent documents. One of it says missing parent documents. Seller has only latest sale deed. Problem is cannot establish the root title. Solution, we have to trace 30 to 40 years of ownership before giving a legal opinion. So missing parent documents, it is not, in my opinion, I do not suggest for a legal opinion. Legal head disputes. In some properties, legal head disputes will be there. The father sold the property without consent of heirs. When it is a joint property and consent of all the joint owners to be taken in consideration, then only property can be sold. Then if it is sold by the father without consent of the legal heirs, then problem which arises, the legal heirs may go for civil court, filing a partition suit and creating a litigation there. So to avoid this, we have to obtain legal head certificate, release deeds, and no objection certificates on the legal heirs. And third one is equitable mortgage. Owner depositing original documents with another bank. EC may not show it. See, as earlier I told that private banks or some private institutions or private mortgages, they don't proceed for, they don't insist for risk mortgage. In such cases, we cannot, these are hidden charges that we cannot trace out. So in such cases, banks have to search original document, custody verification is needed, declaration by the and indemnity by the borrower. These all three we have to take into consideration before these are the take into consideration for processing of the loan. And fourth one is assigned or prohibited land. In AP, this is a common problem. Transfer itself void. Assigned lands and prohibited lands cannot be transferred and not registered also. Transfer is hiding that is not even the register officers reject for if it is an assigned land, sometimes by mistake it may be registered. In such cases also we have to, as an advocate of value, we have to verify whether the property falls under assigned land, or then we have to check it up. And that such a transfer of title is void. Then we have to, for that, for checking up for how to confirm that whether the property is assigned and prohibited land, we have to check the list of 22A. We have to find out whether the properties are in the list of 22A. Nice revenue classification, assignment conditions. If we go through these three and we find out whether the property falls on these three issues, and then it cannot be taken into. It's not having legal validity. Next is fifth one, last and final, GPA transactions. Many believe GPA sale is equal to ownership. That is legal risk. It is having legal risk that GPA in olden days, almost several transactions. Olden days means in 60, 70, 80s also, we come through such documents like as general power of attorney giving to some third party for registration of property. In such cases, that is that convenes to be duly registered. Now, if it is not registered, then the transactions will be void. Not also the power of attorney holder. GPA will be enforceable only until the power of attorney given the principal is alive only. Even after his death, GPA comes into it is not valid. So we have to find out the GPA transactions, the flow of GPA transactions with that these transactions will be the one of the chain documents or link documents to the main parent document, main document, latest document. Some of the common real life scenarios in property matters. In general life, we see siblings fighting over inheritance, fake sellers, double registration of properties, forged signatures in the place of original owners. Fake owners will come and sign the documents, unauthorized layouts, and mortgage fraud, illegal apartment constructions. Most people say, I trusted the seller, but trust without verification is dangerous. Coming to the conclusion, property valuation is not only about square feet, market rate, location. It is equally about title, legality, compliance, risk. A property with the perfect construction but defective title has poor real value. Therefore, from title to trust, legal safeguards transform property into secure value. In property law, every document tells a story. A missing document tells a bigger story. As lawyers, valuers, and bankers, our responsibility is to read both, because valuation creates numbers, but legal safeguards creates trust. And in the end, trust is the most valuable asset of all. I hope you all have understood the salient features, principles involved in the advocate's opinion and valuation. I'm very much thankful for giving me this opportunity. I also thank the chairman, the secretary of the Institution of Valuers, Visakhapatnam. Thank you.
Thank you, ma'am. Now, members, you can ask your questions.
Yes, sir. Any further doubts or questions, anytime anyone can contact me, sir. Number or email.
Actually, our chairman sir also has a doubt.
Yes, sir.
Yes, he'll ask. So, Madhusundaran garu.
Sir,
So please ask your query, sir.
sir, actually, I have not raised any question, but
Sure.
Ma'am, thank you very much for your excellent presentation. You have highlighted the legal aspects of what legal aspects are to be followed and to what extent it is required. All these things you have explained in a very clear and very lucid manner, ma'am. We are highly thankful to you, ma'am. And one question I am asking is, suppose one valuer has done valuation for say a value of X. Now, after beginning the account NPA, why is valued that property about 30% of the value given by the
Sir. Hello. Break. Voice is break, sir.
Yeah.
Voice is breaking, sir.
Voice is break.
So,
Sir, you're as a senior values, you all are aware of what high valuations initially giving with when properties coming for loan. High valuation, what are the repercussions arising from the high valuation certificate report, and later if it is in NPA, if it is 50% of the value of the property, original valuation 50%, and or actually giving double value of the property means, it may bind. Sometimes it may bind valuer also, sir. But he can say, I can some related. What are the related aspects that are at the time of giving valuation maybe prevail, sir. So sometimes it is a risk also, sir. In my view, so that is the thing.
Thank you.
Valuer, I think valuer Sudhir has a doubt.
Yes, sir, please, sir. Values having doubt.
Murthy sir.
Sir.
I'm leaving sir report.
Fine, sir. That's okay, sir. Thank you, sir. Thank you. Yes, sir. Thank you.
Thank you.
Valuer Sudhir, I think you have a question. Can you raise your question?
Madam, what is the difference between lien and attachment, madam?
The attachment is, sir, when attachment comes, it is from a decree, from the court order, sir. It's direct from the court, then property is attached. Lien is it is from bank side only, sir. Bank takes lien. That is not, of course, it is as per bank rules. Lien is also valid, sir. That is up to the bank only. If it is attachment, means court directs, court gives the attachment order. Then if we go to the court to attach the property, court gives directions to attach the property, may give a may not. That is having more. We can claim, we can attach the property, and it will. He cannot sell the property to anybody anytime. That attachment order is claimed by the court. That particular property cannot be sold, sir. That is sold.
Hello?
Yes, sir. Hello. Sir, can you follow me, sir? A lien is, yes, sir. A lien is a legal right to retain the portion of the property until the debt or obligation is paid. This is attachment means when we approach the court, particularly to for recover the amount of something, to attach the property from the with the direction of the court only. Property will attach, that cannot be sold by the borrower. Not borrower means owner of the property. It cannot be sold, sir, at any time until the loan is cleared. Borrower cannot touch the owner of the property cannot touch it.
One more question, madam. Sir, can you give me a brief description of the limitations of the case of GPA deed?
GPA in general, I can tell you, sir. GPA, it will persist until the GPA executed by the GPA holder is alive only, sir. Once the GPA principle of the GPA expires, the GPA comes into, it is nullified, sir. In the lifetime of the GPA, principle of GPA only, the GPA holder can enforce that GPA deed.
How the registrar knows that the GPA who has given is live or not?
Sir, that we have to verify personally, sir. Means no, we can't insist on. Register cannot find out the register that is GPA holder is alive or not. That is not possible, sir. And we have to feed the views. We have to take some information. We have to go through and find out whether GPA holder is there alive or not. And research, it's not the duty of the research to find out that, sir. And he cannot find also.
Suppose if the GPA person who has given is not alive,
yeah,
the GPA holder made it as a secret or hidden it, and he do the registration for others. What will be the result of that?
Sir, unless and until the contest comes with respect to the property, contest means that when it claims the property, until then it is hidden only, sir. The truth is hidden. The truth is hidden. If once the person who claims the property finds out and tells the brings it into limelight that GPA holder, the GPA holder is the principal of GPA died long back. Then he can approach the court and he can cancel that. That sale is void also. It will it is not valid, sir. Then court will definitely cite of the sale, decrease that the sale is void.
And one more question, madam. What is the consequence of giving the advances to the customer by keeping it the title without mortgaging the registration, registered mortgage? What are the risk factors
Risk
for
factors, sir?
banks? For banks,
Yes, from bank side, sir, it is a very risk, sir, because without registered mortgage, it must be known to the public, sir, that particular property. If he sells the property by creating fake document, then the purchaser will not be knowing that the particular property is in mortgage. So there is every chance of creating a fake document, and he can sell the property. If unless until it is registered mortgage, then we can find out property, whether any uncovered charges, claims, attachments, etc. over that property. Unless until then, it is a risk factor, sir.
but why the financial institutions are giving loans to the customer?
Financial institutions means, sir, which nationalized banks are. We insist for nationalized banks also. NBFCs also insist for nowadays. They are also insisting for registered mortgage because sir, registered stamp duty for mortgages is it will be more, sir. For the borrowers, they feel that why to pay the stamp duty to the registered office. So in such case, these institutions also will to avoid that borrower going away from their from them, to taking any loans, to avoid such cases also, such things. They are not, some are not insisting for registered mortgages.
And some of the NBFCs and financial institutions are giving loans on a single document without any link.
No, sir. That is, sir, in cases of, see, it is a Voda plot means we may not have linked documents, sir. Only Voda proceedings will be there, that's all. Voda directly sells the property, or API sells the direct property, then in such cases, we do not have any linked documents. We have directly only the main one document. Unless until you do second sale, like the second sale or third sale, like that, we'll get linked documents.
Sometimes we are observing that the single document which is giving us for the valuation, there is only settlement, or there is something like a gift or something like a partition. We're saying that it is the ancestral property and they are giving gift to the others. And the financial institutions are accepting that single document also, not like Voda approved labor.
Yeah, ma'am, actually, I just want to add one point to that. In the same settlement deed, they are writing that along with the half portion you have, the other portion I am transferring it to you. They're not saying that, the complete portion I have today, I'm transferring it to you. They're saying that along with the half portion, even though it's a single document, they're saying along with the half portion, I'm transferring the other half portion to you. So here, absolutely, there's no clarity for us, and there is no link document or nothing. And sometimes we get unregistered will also in such cases. Even not only settlement deed, we are getting unregistered will also. So how far these documents are valid?
In such cases, you have to insist for if it is unregistered documents. If it is agricultural land means we'll insist for 1B, but other process like that, sir. If it is urban properties or commercial residential properties, definitely we cannot consider such documents, sir. In my view is I cannot consider such document without any link. without any, even if 30 years back old ancestral property, anything, we must have some one link, sir. At any one link also it must be there. Without a link, we cannot give. Even if we say will also it is if unregistered means there's every problem for litigation because it may be forged, created, something. Means only registered wills only we can take into consideration for value, either valuation or legal opinion. Because value depends upon the title due diligence report given by the advocate. Seeing on our opinion only you will be giving, sir. That is for in my practice, I don't accept any single document inside such type of documents without any link. I insist for link. Even if it is 30 years old document also, I insist for link. Because in 30 years document, I don't know how the property as a parent title, root of the title has come.
Yes, but most of the NBFCs has a product or policy that
Yes,
they do fund a property which is having a heritage of 5 years or 10 years of tax receipts. And you know well that India is popular for getting tax assessment for unauthorized properties also. So
Yes.
they are saying, sir, we have a policy. If you raise a query, we'll mail you on that, saying that you can do this as per our internal policy. So how to handle this? Because we do get every day these documents, a single document with no other base or adangal or whatever it is.
Yes, sir.
So do tax receipts can under the possession of 10 years or 5 years do really matter
No.
as himself as owner?
No, sir. Mere tax, paying of taxes, property taxes is in a particular person's name doesn't confer any title or ownership on the property, sir. So we cannot consider. Just it is, we can confirm that the person is staying there and he's possessing the property since then. That's all. Nothing more than we cannot assume things from simple submission of taxes of 5 years or 10 years. That doesn't mean confirmation of real ownership or title itself.
Okay, ma'am. We'll fight our best with the NBFCs, especially these cases come under NBFC.
Because, sir, one point. In private institutions, we have more NPA accounts because of this only, sir. Because they're submitting like that, they're taking loans, and number of cases from ICC, and where number of private institutions are there in DRT. That is the thing, sir.
Okay, ma'am.
Okay.
Understood. My next cyber facility questions and my wife can I?
You carry on, sir. You carry on.
Yeah, please. Thank you, sir. Ma'am, actually, we get documents with only mentioning boundaries, no dimensions in that.
Hmm.
And when we go, normally we see okay, this can be a boundary, and we are measuring that. And banks are insisting us to measure the poles. It can be a 1 feet pole or a 5 feet pole or whatever it is. They are asking, and against no dimension in the deed, we are mentioning some dimensions as per the site condition. Especially this happens in the Konaseema region, where they build houses in the coconut farms and all. So they write that 400 square yards or whatever it is, and they say no different things in the deed, but we do not get the dimensions. Normally, we take the criteria of dimensions to arrive to the area. So area may be matching, but we don't know the dimensions. So can we consider the boundaries as the periphery of the property? I heard that this has been mentioned in Revenue Act that based on the boundary, earlier when the survey has been done way back before independence in 1936-7, there is some, no, because recently I spoke to an MRO, he told that boundaries only were there earlier. So you can consider boundaries if they are matching. So if they're matching, it's okay. But normally boundaries do change time to time because of selling the properties, and part of the properties are being sold, and sometimes they give the access to the behind properties. So how to handle this? Can we consider if boundaries are matching? Can we consider that as the whole periphery of the boundary property?
Sir, yes, sir. Sir, one legal maxim is that legal boundaries prevail the ownership, sir. Legal boundaries we can consider, we can consider that it's legally valid. What are the boundaries prevailing there? We can consider that, sir. Within the framework of the boundaries, that property can be taken into consideration, sir. We can do it. And the subdivisions, if further the property is sold, half of the property, some of the part of the property is sold, then sold means then the existing document will be linked with the running document, and we can match these documents, seeing the boundaries of this document and that document, latest document and old document. That is the only way. Other than because ownership doesn't differ, only boundaries you are only claiming with respect to the dimensions only, not the ownership and everything.
So in the most of the cases, we are asking for the legal report, ma'am, so that at least it can be supportive, and we are mentioning that legal report also in our report, and we are releasing, because nowadays there is a lot of pressure that every file should be through. We are still fighting with that whole scenario, but boundaries can define the property periphery. That's the point I have noted.
Yes, yes, 100% you can go, sir.
Yes, ma'am. Now, coming back to apartments, when builders are selling apartments, they are writing one number. Let us say G1. And after a certain period of time, when the apartment association forms, they are converting them to, based on their numerical numerology and all, they are converting it to 101, 102, like that.
Yes, 102
floors. How to handle this conflict? Can we really based on the legal report, can we go? Because this transformation, sometimes nobody is providing any support to this transformation. I'm either I'm valuing for G1 or 101. This, how to handle this issue?
Sir, if at the initial stage means we go through the plan, sir. According to the plan, approved plan, we'll do it, sir. And if it is already an existing flat, if it is an old flat, we'll go for the door number will be available, sir. Based on door number, we have to check out whether it is G1 or 101, something like that. That one, sir.
But ma'am, can we consider the board that they display in the parking floor? They keep that so-and-so apartment association, and then they write the ownership name against the flat number. So can we justify this conflict with the board that is there being displayed openly in the apartment parking? Can we do that? Can it be a justification or evidence for our justification? Can we use that?
Sir, that is that appears that is will be taken into consideration only at the time of fresh apartments. Fresh, that is means first original owner's names will be only displayed. Okay. And if the property is sold, second sale or third sale, it's done. Sometimes it may be not the name of the latest owner may not be changed on display board. So how you cannot consider it, sir?
No, ma'am. Actually, when these are matching, when my deed or applicant is matching with the board, yes, and the name is changed against deed, there is G1. But in the board, it's been written as 101 so-and-so name, and even applicant also 101 so-and-so name. So can we justify that way if the name is matching?
Yes, you can justify means you can write it as a G1/101. If it is
G1/101, yes. But ma'am, we are not here to decide whether it's both are right. No, we cannot justify and mention G1/101. There might be some conflict there also. So however, we are mentioning some comments, remarks at the bottom of the report, but we are presently going with the physical evidence there. What it has been displayed, maybe at the flat, and even the number that has been displayed on the tax receipt actually. So we are mentioning that in the deed it's G1, but as per tax and the physical possession there, it has been displayed as 101 only. So we are considering it as 101 and legal report to be verified in this regard. Similar comments we are mentioning there.
Yes, sir. Based on documents and physical verification, here as a physical verification, you have verified that it is displayed on G1, and as for the tax receipt, it is G1. We will mention both, sir, because we should not be come under any risk, sir. So, based on door number, assessment number, will confine you.
Do that.
Though assessment will confirm the genuinity of the flat number. So,
and ma'am, actually, survey number mismatch is a big issue for us from long time. Survey number mismatch is like in deeds they mention something, and
Yes.
but as per physical, it will be in the prohibited list.
yes, sir.
So by manipulating some part at registry office, they're changing the adjacent thing and they're registering.
Yes, sir.
So how to handle this? Because see, many a times we cannot, because there will be a building there and they'll be residing for almost more than 10-15 years there.
Yes, sir.
Bank will be insisting to release the report, but here the survey number that is there physically, that will be in the prohibited list. So can we really rely on legal report? Can we ask for legal report, and with the support of legal report, can we release the report or not?
Sir, in these, this is the commonly focused points, sir, because since this when the properties are when Section 22 has come into life, many of the apartments, many of the prime properties also are under 20 section, because and we are I'm in some cases in apartments or something, some properties we are asking to take an endorsement from GMC that this particular property, so if there are 3 or 4 survey numbers, they give us this property falls under this is not, this particular survey number is not in a 10-A section. We are particularly insisting for endorsement from GMC, sir. GMC that the service number is not under 22A. Basing on that only, we are going. See, since even I am residing in my apartment, it is 40 years old, sir. Even there are 3 survey numbers here. One of the survey number is 22A. So if you go for loan means if these are one of the survey number is 22A, then taking endorsement from GMC and taking this particular survey number, some they will go do some subdivisions or something, says that it is not in some major things, sir. And I don't suggest you to take in all the things and all properties like that. Some of the light, small problems in such of these problems, since it is we are staying here 30 to 40 years or 20 years, paying tax receipts and everything is there. Then 22A, by mistake, some of the properties are under 22A. Nowadays, I think it has been lifted by the government also. Latest government has all lifted it. So that is the problem, sir. Actually, it is not by mistake. Some of the properties are kept under 22A. And previously, I instituted for endorsement from GMC only. Then confirmation basing on that, we have to, and basing on door number, assessment and everything, documents, we rely on that, and we proceed to give an opinion.
And ma'am, actually, the next question is like many a times in rural areas we see crosses, and
Yes.
to several reasons, like maybe some want to construct for at True North, and they leave the crosses outside. So they build a compound wall, leaving the crosses outside.
Yes, sir.
But no, we never know whether those crosses has been adjusted to the neighbors or not. But they build compound wall in a very proper 90 degrees angle. So these crosses outside the boundary wall, how to judge them whether they are part of this deed, or maybe they have adjusted that cross with the neighboring people or not? How to handle this, because there will be no document evidence, just by on mouth's word they'll exchange the land. So how to handle this? Do we need to follow strictly with the compound wall area?
Sir, we have to base on the document. What is the extent based in the sale deed or something, etc. In title deed, registered. Basing on only that deed, but extent may be more, extent may be less. We have to mention only what is the extent mentioned in the sale deed. Nothing more than that we cannot take into consideration, sir. If the owner has left it as a cross also, that also it has to take into consideration. At the piece of land also we have to mention, because the total extent is including with the cross. So we have to mention as per the sale deed mentioned in the sale deed, extent mentioned in the sale deed only.
Okay, ma'am. Right. Thank you. And again, the next one is
Upesh garu, last question, please. Any further questions? No, please post in the personal window. We can get all the clarification from ma'am. Okay. Thank you.
I'm done, sir. Thank you.
Yeah. Thank you. Ma'am, like any further questions, no, we'll post in the window, ma'am. Kindly, get the give us the clarification.
Okay, sir. Thank you very much, sir.
Okay, yeah. Thank you, ma'am. Thank you very much. On behalf of Institute of Valuers, Visakhapatnam branch, I extend our
Thank you.
gratitude to our esteemed speaker, Madam Padmaja, for delivering such an insightful and information session today. Ma'am, your expert guidance on the legal aspects relevant to the valuation profession has greatly enriched our understanding and provided valuable practical insights. We truly appreciate the time, effort, and expertise you have shared with us. And especially, ma'am, the time you have taken in preparing all these slides, point-wise and all, it's really marvelous, ma'am. And most of us, whenever we go for surface and all, we do a lot of valuations. But today, you're really given us thrown us more light on what exactly surface is by giving the all inputs. Thank you, ma'am. Thank you once again for your valuable time, and I thank all our members who have attended today. And thanks for Devi Prasad Garu for introducing Madam Padmaja.
Thank you very much, madam.
And I thank
Nice presentation.
Sai Prasad Garu, our treasurer, who's continuously supporting us with this webinars and with this staff especially. And I thank other members and okay, our vice chairman, Srinivas Garu. Thank you, sir. Thank you. Good evening.
Yeah.
Thank you, ma'am.
Thank you, sir. Thank
Madam,
you.
I request you, if you have any, no problem, please share the PPT, madam. The other persons are asking.
Sir, already shared with
Can you share
the
it?
officer. I already shared with the
Okay.
officer.
If you give the permission, we will share the same in our group.
Yes, sir, you can share it, sir. Thank you.
Thank you, ma'am.
Okay, ma'am. Okay. But we have to take your concern. Thank you, ma'am. Thank you.
Thank you. Okay, sir. Thank you. Welcome, sir.
You have clarified so many points. Everybody is
sir.
satisfied now.
Thank you. Thank you, sir. Because of you, I have got this opportunity. Thank you, sir.
Okay.
If you are satisfied, everything is satisfied, sir.
Okay. Thank
You have
you.
covered almost most of the points, ma'am.
Exactly.
Yes, sir.
And especially
Number of
the
points are
queries,
covered.
you have addressed the queries. That's very
Yeah,
important.
what is this? Because in regular practice, we are doing no, sir.
Yes,
So,
sir. That is true.
thoughtfully, I can be like this.
No,
Okay.
that's what that is the idea why we have requested you to give your lecture, man, because see your experience will definitely help us,
Yes, yes.
and moreover we need support from legal advisor, we need your advice. I may know as and when we have any doubts or anything,
Definitely, sir. You're welcome, sir. Okay, sir. Okay, sir. Thanks.
That's the main idea of introducing you here, ma'am, today.
Thank you very much, sir.
Thank you, ma'am. Thank you once again.
Always you can call me, sir.
Yes, ma'am. Thank you, ma'am. Thank you.
Thank you, madam. Thank you.